picture this. You are standing at the altar.
Oh, yeah. The absolute best day of your life, right?
Exactly. Or, maybe you're at the end of this gorgeous beach and you are just looking into the eyes of the person you love most in the world.
Counts perfect.
It is. You are surrounded by flowers. Your favorite people are crying, happy tears. I mean, you are about to make the ultimate romantic commitment.
Pure magic.
It is pure magic. But underneath all that magic, literally the second you say, I do.
Boom. You're in a legal merger.
Boom, exactly. You are agreeing to a massive, incredibly complex legal and financial merger. I mean, it is remarkably similar to a corporate merger, just, with a lot more feelings involved.
A lot more feelings. And that's the part nobody really wants to think about while they're tasting wedding cakes.
Right. But that is why we are here. Welcome to the deep dive. We are talking directly to you today because if you are tuning in, you are likely navigating the incredibly dense weeds of planning a future with someone.
Yeah, it's a lot of work.
It is. Maybe you are currently utilizing the Weddizer website to manage your finances or, for venue selection purposes.
Which is such a huge help when you're overwhelmed.
Oh, totally. And, you can find the best guidance for your wedding events through the articles section on their website related to this niche. And if you've been reading those articles, you have probably stumbled across the exact dilemma we are unpacking today.
Right. That tension between the romance and the state-recognized partnership. That is where so many couples find themselves completely stuck.
Yeah.
Because we are socially conditioned to view marriage strictly through the lens of a fairy tale.
Of course we are.
But the legal system fundamentally views it as an economic partnership. And navigating the gap between those two realities is, well, it's demanding.
It really is. And bridging that gap brings us to our focus today. Okay, let's unpack this. We are looking at a highly relevant but incredibly divisive guide from the Weddizer platform titled The Pros and Cons of a Prenuptial Agreement Before Marriage.
The classic romance killer. Or so people think.
Right. We are looking at whether these documents are practical, necessary financial planning tools for modern couples, or, if they're just inherently unromantic contracts that inject a fatal dose of pessimism into a relationship before it even starts.
It's a heavy question.
It is. So we are going to strip away the heavy emotion, look at the cold economics, and give you the ultimate cheat sheet on how these contracts actually function.
And to do that effectively, we really have to start by completely discarding the Hollywood drama surrounding prenups.
Oh, the soap opera versions?
Exactly. The media portrays them as these weapons used by warring billionaires.
Oh.
But the legal reality is much more mundane and, frankly, much more useful.
Right.
A prenuptial agreement is simply a legally binding contract signed before the wedding that establishes the financial rules of your specific marriage.
Because, and this is the crazy part, if you do not write your own prenup, the state you live in already has one written for you.
Yeah, the default marriage laws. And you might not like them.
Exactly. A custom prenup dictates exactly how your assets, your bets, and your financial responsibilities will be handled during the marriage.
And crucially, how they'll be divided in the event of a divorce or death.
Right. We are talking about laying out a concrete framework here, stuff like property division, assigning responsibility for specific debts.
Setting parameters for alimony or spousal support, which is huge.
Oh, for sure. And outlining business ownership and inheritance rights.
Yeah. And when you lay it out like that, it becomes really clear why the first major misconception highlighted in the source material is, well, it's totally wrong.
The idea that prenups are exclusively for the ultra-wealthy.
Exactly. You do not need a fleet of private jets or a secret offshore account to benefit from financial clarity.
Right.
The mechanisms of a prenup protect a middle-class income just as fiercely as a billion-dollar portfolio.
That makes total sense. But there is also this pervasive second myth, right? That asking for a prenup means you are predicting a divorce.
Yeah, people assume it is an admission of inevitable failure.
Which is wild to me. I look at it through the lens of financial fire insurance.
Oh, I like that.
Right. You do not buy fire insurance because you expect your house to burn down.
No, obviously not.
You don't sit in your living room looking at the drywall thinking, well, this will be ashes by Tuesday.
No, you'd be crazy.
You buy the policy so you have a safety net if the absolute worst case scenario occurs. But here is the catch with that metaphor, and where I think couples get into trouble.
Okay.
You have to treat it as a living document. Just like real insurance, you have to update your policy if you build a massive extension on the house.
That's a really good point.
You cannot rely on a policy you bought for a tiny starter home when you now live in a sprawling estate. But let me push back for a second here.
Okay, go ahead.
Doesn't drafting a legal document for your potential breakup fundamentally alter the romance of the beginning? Like, doesn't it just kill the vibe?
Well, what's fascinating here is how the source explicitly tackles that psychological shift. It defines a prenup as a precaution, not a prediction.
A precaution.
Yes, it is fundamentally an exercise in preparation, not expectation. When couples manage to remove the emotional stigma and approach the drafting process as a structural exercise, it demands a level of vulnerability that can actually deepen trust.
Oh, wow.
Yeah, you aren't plotting an escape route. You are
Yeah.
actively defining the operational rules of your partnership while you still have a deep reservoir of goodwill toward one another.
Which is undeniably better than trying to define those rules when you are communicating exclusively through expensive, angry litigation attorneys 5 years down the line.
Absolutely.
You are making sweeping financial decisions from a place of mutual respect rather than a place of resentment. So let's examine the mechanics of what we are actually preparing for, the practical pros.
Right, because the benefits go far beyond the cliche of just protecting the giant pile of cash. The utility of these documents is vast.
So what's the biggest one?
Well, the most immediate benefit is asset protection. If you are entering the marriage with significant personal wealth, real estate, or, premarital investments, a prenup mathematically walls those off from the marital pot.
Okay, that makes sense.
But the mechanism that often gets overlooked, which is arguably more vital for the modern economy, is the protection of business interests.
Oh, right. If you are an entrepreneur or a startup founder, a prenup is essentially mandatory.
It really is. Without one, a judge could look at the value your business gained during the marriage and decide your ex-spouse is entitled to half of that growth.
Yikes. And to satisfy that judgment, you might be forced to liquidate business assets, or worse, award actual equity to your ex.
Exactly. Imagine the nightmare scenario for your co-founders.
Oh, man.
You spend 10 years building a successful company with two other partners. You get married without a prenup, eventually divorce, and suddenly your ex-spouse has a legally mandated seat at the boardroom table.
Or voting rights on company decisions. That's terrifying.
Right. A properly drafted prenup prevents that specific financial disruption. It keeps the business equity insulated and maintains operational control where it belongs.
It protects your colleagues and your employees just as much as it protects you.
Exactly.
And the same insulating mechanism applies to family inheritance too, right? Particularly in blended families.
Oh, yeah, that is a crucial point. If you have children from a previous relationship, the default inheritance laws in many states can accidentally disinherit your kids if you pass away.
Wait, really?
Yeah. The state might route your assets entirely to your new spouse. A prenup allows you to legally override those default probate laws, guaranteeing that the wealth you built specifically for your children actually reaches them.
That is massive. But we also have to look at the other side of the ledger, right? Debt.
Oh, for sure.
Yeah.
A prenup is incredibly effective at isolating liabilities.
So if your partner is bringing like $200,000 of medical debt or high-interest business loans into the marriage.
A prenup can explicitly state that those obligations remain separate. It prevents creditors from coming after your joint savings or your personal assets to satisfy a debt you had literally no part in creating.
Okay, here's where it gets really interesting. Beyond the massive structural protections, there is a fascinating paradox the guide points out regarding day-to-day financial clarity.
The communication paradox.
Yes. The very act of talking about divorce, which is the core function of drafting a prenup, actually encourages a level of honest communication that most couples never achieve.
So true.
It forces you to sit down, open every bank app, pull every credit report, and put your entire financial reality onto a shared spreadsheet.
And the mechanism behind why this forced communication works is deeply rooted in conflict psychology.
How so?
Well, statistically, financial incompatibility is a leading driver of relationship dissolution. Couples engage in chronic warfare over hidden credit card balances, mismatched savings goals, unspoken expectations about who pays for what.
Yeah, money fights are the worst.
They are. By forcing total, unvarnished financial transparency up front, the prenup process acts as a massive pressure release valve. You are identifying and neutralizing the biggest financial landmines before you even walk down the aisle.
You are building a stronger foundation by acknowledging the cracks.
Exactly.
And if the marriage does eventually fail, having that pre-negotiated document lowers the legal costs astronomically. I mean, you bypass the years of discovery and mediation because you already wrote the playbook when you were happy and thinking rationally.
It's just smart planning.
It sounds amazing on paper, a flawless strategy for financial harmony and risk mitigation. But if forced communication is so beneficial, why does bringing up a prenup over a romantic dinner usually result in someone sleeping on the couch?
Because the emotional discomfort is monumental, and it cannot be understated. Presenting a prenup can feel like dropping a bomb on the romance.
I can imagine.
For the partner receiving the request, it is frequently interpreted as an immediate lack of trust, or, a heavily telegraphed lack of commitment.
Right. Imagine you are the one bringing this up. How do you look at your partner across the table and say, hey, I am committing my life to you, but I need you to sign this legal waiver just in case my commitment expires in a few years?
It's tough.
It introduces a deeply transactional, adversarial energy into what is supposed to be an unconditional emotional union. You are basically asking them to plan for your mutual failure.
Yeah, and that psychological weight is heavily compounded by the sheer legal complexity of the process.
That's not cheap, is it?
Not at all. Creating a valid prenuptial agreement is not a matter of downloading a generic template and signing it at your kitchen table with a notary. It is a grueling, expensive, and highly bureaucratic undertaking that requires specialized legal counsel.
And even if you endure the emotional friction and you pay the thousands of dollars in legal fees, courts are not just blindly rubber stamping these contracts, right?
No, absolutely not. There is a strict legal standard known as unconscionability.
Okay, what does that mean?
Well, if a judge looks at the document during a divorce proceeding and sees that one partner was completely legally bulldozed, say, left entirely destitute, while the other walks away with millions, they have the authority to throw the entire agreement out.
Really? Just toss it.
Yep. The state has a vested interest in ensuring a divorced spouse doesn't become a ward of the state while the other lives in luxury.
Wow.
The courts will also invalidate the contract if there is any evidence of coercion or duress. You cannot slide a dense legal document across the table the night before the wedding and say, sign this or the wedding is off.
Right, that completely violates the legal requirement for voluntary consent.
Exactly. If the drafting was rushed, or if the terms are so egregiously one-sided that no rational person would have signed it without undue pressure, the judge will simply dissolve the contract.
Which brings us back to the flaw in my fire insurance metaphor earlier, the problem of the static document.
Ah,
The guide explicitly highlights future blind spots as a major vulnerability. Because a prenup is drafted at a highly specific moment in time, but the trajectory of a human life is incredibly fluid.
it changes constantly.
Right. You might draft an agreement when you are 25, making identical salaries and splitting the rent. But what happens if you decide to have 3 children and one of you sacrifices your entire earning potential to stay home and raise them?
That's a huge shift.
A document that made sense when you were both working professionals suddenly fails to capture the economic reality of a 40-year-old who has been out of the workforce for a decade.
This raises an important question, though, regarding how a static document handles that fluid nature of a lifelong partnership. That is the precise danger of treating a prenup as a set-it-and-forget-it solution.
Right. If the document can't easily account for future life changes like a sudden career shift or having kids, isn't a prenup just a financial snapshot of the past?
It is. If it cannot accommodate massive shifts in career, health, or family structure, it becomes obsolete. It inherently fails to protect the partnership as it exists in the present.
Given all these massive hurdles, I mean, the potential to obliterate the romance, the strict legal threshold for unconscionability, the danger of future blind spots, how do couples actually execute this successfully?
Well, the Weddizer article offers a very specific playbook for making it work. Not just for getting it signed, but for ensuring it survives a judge's scrutiny down the line.
So what does this all mean? Who actually needs to do this?
The first step is identifying if you actually have the risk profile that necessitates one. We established that it is not just for billionaires,
Right.
but it is highly recommended if you are entering the marriage with significant uneven debt, if you own a business, if you are entering a second marriage, or if there's a massive disparity in your earning potentials.
Okay. And if you fall into those categories, what's the playbook?
The execution strategy revolves entirely around fairness and timing. There are 5 rules of creation.
Okay, lay them on me.
Rule 1, start the conversation early. This is critical to avoiding that legal threshold of duress we just talked about.
Right. No ticking clocks.
Exactly. You cannot bring this up while you are finalizing the seating chart or tasting the catering menu. Introducing the concept months in advance removes the pressure.